roots and became entrenched, what the world had never been told all along is that there was not one decision, not two decisions, not three of them, but in fact, the courts of this republic, presided over by judges and magistrates of various cadres, of various qualifications, of various ethnicities, of various races, all of them, in all those allegations, without exception, ruled in favor of the man. You have now been told, to use the mover's words, the world has such a bad perception about him. He's a man of such terrible character. And because he has been given such a terrible name, if the Honorable Wamboka says he's a murderer, then we take it, line, bait, hook, and sinker. Because this man has been painted for 5 years as a crook, as a fraudster, as whatever you may wish. If Honorable Wamboka says this man is implicated in the fertilizer scandal, then it must be true. After all, the allegation is made against the Honorable Linturi. It is in that context we submit to you, and I'll be showing it shortly. It is not coincidental. You kept hearing from the mover, from his counsel, that perception is enough. Because we have such a bad perception, such a bad single story about this man. We should send him to the guillotine, we should crucify him, and if we allege he has killed somebody, we don't even apply our minds. It is Linturi after all. If we say he has stolen somebody's wife, we don't apply our minds. After all, it is Linturi. If we say he was in the fertilizer scandal, yeah, we can shut our minds. You mean it's Linturi? Yeah, it must be true. And that is the context in which I beseech you to watch before you deliberate this very famous TED talk show by the graceful lady from Nigeria about the dangers of a single story. But why am I warning us about these dangers? It is because our system of justice itself, whether it is Article 50 of our Constitution, whether it is the oath of office for judges that I alluded to 2 days ago, whether it is our Article 49, whether it is our Article 47 that the Speaker himself referred to when he said about these proceedings being quasi-judicial, whether it is the Evidence Act, I could go on and on and on, but the point I'm trying to tell you is that all these instruments are founded on the assumption that you cannot approach a matter such as the one before you from the perspective of a single story. Section 55 of our Evidence Act in subsection 1, and I read, says, Honorable Chair, that in civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is inadmissible. Those are not my words. It is the words of our Evidence Act as written by the British in the year 1872, the later on exported to Kenya in the year 1897 through the East African Order in Council of 12th August 1897. That's how long ago Kenya adopted a law on the dangers of a single story, and the long and short of it is you have been told in black and white that the fact that the man accused before you is a man with a terrible character, reputation, disposition, or whatever, is immaterial and inapplicable. Section 57 of the same Act again says, Honorable Chair and members, that in criminal cases, the fact that the accused person has committed or has been convicted of or charged with any offense other than the one with which he is then charged or is of bad character is inadmissible. It is in that context that our Constitution says everyone enjoys the presumption of innocence until his guilt is proved, and I'm here shortly to show you that the guilt of the Honorable Linturi has not been proved. I'll read for you again, Honorable Chair, a decision of the famous House of Lords, again issued in the year 1893, that is 131 years ago, about the dangers of a single story, the dangers of prejudice, and it is a decision called John McKean and Sarah McKean versus Attorney General for New South Wales. Just in case your staff want to retrieve it for you, it is in the 1893 volume of the appeal cases at page 57. And if I may read what one of the most famous judges in the Anglophone world ruled in that case, quote unquote, it is not competent for the prosecution to adduce evidence tending to show you that the accused has been guilty of any criminal acts other than those covered by the indictment for the purpose of leading to the conclusion that that the accused is a person likely from his criminal conduct or character to have committed the offense with which he is charged. Honorable Chair, I'm making all this because contrary to what the spinning that has been attempted, it is not Honorable Linturi that brought to you that the two cases of love and affection as the basis for the accusations before you. It is the mover of the motion who has listed these cases in ground 2, and he is telling you because there were those cases, never mind they were all without exception determined in favor of the Honorable Linturi, he's telling you, yeah, he has such a bad perception, let us crucify him. Again, Chair, this will surprise many of us. And because it will surprise many of us, I want to say it slowly. A lot has been said about democracy, about the 149 votes that voted in favor of this motion. A lot has been said about poor, suffering farmers. I'm here to very politely tell you that, again, our law forbids you from considering any of those things in Article 52A about the presumption of innocence. I'm here to tell you, actually, we have a decision on whether public sentiment, democracy as we call it, what the masses will, is a relevant consideration in a matter like the one before you. And why I said it will surprise many of us is, one, it is of course forbidden by the constitutional provision on presumption of innocence. It is forbidden by all those cases I have read and those sections. But there is actually a South African decision again called S versus Makwanyane, which I hope your secretariat will retrieve for you, that says in black and white, the fact that the masses are being out there, crucify him, is not a relevant consideration, not when you're sitting as judges. And I think I said previously, you're seated here not as the representatives of your constituencies, not as members of parliament. The Speaker himself said you're sitting as a quasi-judicial tribunal, and justice is required to be administered without regard to the clamor and the seductions of a baying mob. What is the allegation against the Honorable Linturi? We said there are three, Honorable Chair. And in the first one you're told, it appears. You have not even been told Linturi has done it. You have been told it appears that he is guilty of gross violations of the Constitution. You know, when I was in law school more than 20 years ago, Chair, we were taught in a subject called criminology some controversial theories where you would look at a person's features, how big their ears are, how long and crooked their nose is, whether they are squint-eyed, whether they have a goatee, whether they have rough hairstyle, and based on those apparent features in that discredited school of criminology, then you could conclude this one must be guilty of the offense charged. That is what the mover brought you. He told you, it appears the man he seems to be very unhappy with has committed a gross violation. I have looked at Linturi for several years. I don't know whether I have seen it appearing, and I urge you to look at him in the room and tell us, how would you, looking at that gentleman, conclude it appears? You know, because I don't like his face, therefore he must be guilty of the offense. Can we in good conscience, Honorable Chair, say that a man or a woman is guilty, not just of a violation, but a gross violation of our Constitution because it appears when we look at him, I don't know whether with our glasses in my case or with the naked eye or under a microscope, we weren't told how he was looked at to arrive at this conclusion. And of course, when we pushed this in cross-examination, the answer we got is that he has such a bad public image. He has such a terrible reputation, which unfortunately we were able to demonstrate to you beyond any shadow of doubt is a reputation that has been created by the previous administration merely because him and others who are subjected to different forms of persecution were in support of the presidential candidature of the Honorable William Ruto. You're told in allegation 2, Honorable Chair, unfortunately this is the allegation on love and affection, you're told there are serious reasons to believe that the Honorable Linturi committed a crime under national law and certain sections of the Penal Code were cited. The material that was placed before you, not by the Honorable Linturi, but by the move of the motion, was some 32 cases that arose from a relationship gone sour. And Honorable Chair, I found myself asking a number of questions, which I urge you to join me in also asking yourselves. When the drafters of our Constitution drafted that document, and specifically drafted Article 152, did they intend that Article 152 on dismissal of cabinet secretaries could be invoked to pursue matters vendetta attributable to personal love and affection? That's question number one. Because it is the mover who has based that ground on matters of personal love and affection. Is that what the drafters of our Constitution intended to be the use for Article 152? But, Honorable Chair, can failure to fall in love with someone, love is supposed to be voluntary. Can love be forced at the risk that if I refuse to fall in love with someone, then if I become cabinet secretary someday, they can bring a ground like ground 2 before you? This one I ask for my own personal reasons, Chair. When I was in the love market, I was quite prolific. And I have a number of exes. And I want to believe I have the potential one day to rise to be also a big man like Linturi and the honorable members of this committee. And I've been wondering, should God answer those prayers? Will one of my exes look for a member of parliament, give them 32 personal disputes, and tell them, use this as a ground to ask His Excellency the President to dismiss Dr. Mudomi as a cabinet secretary? Is that really why we adopted our 2010 Constitution? But more importantly, I found myself asking a third question. If the courts of Kenya, all of them, have ruled in favor of the Honorable Linturi, you know, if we are talking one case, Honorable Chair, we would say it was a random luck, that's why he won. If we were talking two cases, or three, we would say it was a string of luck. But we are saying the Honorable Linturi won all these 32 cases in the courts of the Republic of Kenya, spread across the entire judicial hierarchy. So the question is, will Linturi have to win these cases before the Honorable Member for Aldai so that he can have peace? The question of principal chair. Can the House in good conscience, can this committee in good conscience advise His Excellency the President to dismiss the Honorable Linturi because of cases of personal love and affection which all the judges of Kenya have ruled in his favor? Does this committee even have capacity to sit in appeal against decisions rendered in all those 32 cases? The fourth question I found myself asking about this matter before you, let's even assume for a moment that these were not matters of personal love and affection. Let's assume they were more substantial things for argument's sake. But it is common ground that these cases were considered by the House when it approved the nomination of the Honorable Linturi as a Cabinet Secretary. And the million-dollar question for me is, can this committee sit in appeal against the resolution the House made in 2022, 2 years ago, to approve the nomination of the Honorable Franklin Mithika Linturi as a Cabinet Secretary, notwithstanding those cases? Allegation number 3, Honorable Chair, was that the Honorable Linturi is guilty of gross misconduct for two reasons. One, it was alleged he was in a public spot, not a private spot in some private residence. No, a public spot with journalists. No journalist came to testify before you. No journalist saw a witness statement before you. Even the request for summoning witnesses, it is quite telling, and I know you have ruled on it. There was no request to summon any of those journalists. This room is full of journalists. I expected, even if there were difficulties, you know, they could point to one of them and say, it is that one who was involved. Let it come here and explain to this committee about this part. Journalists work with cameras, and I mean video cameras. We live in a world where everyone has a mobile phone to record a public spot. You are not shown. Now, even if we assume Linturi is the alter ego of Lucifer, surely we cannot advise His Excellency to dismiss him for this allegation. Even if we were to assume Linturi is the twin brother of Lucifer, this is an allegation. You know, they say, Mgala mhue na haki umpe. You may not like the guy. You may hate him to the core recesses of your heart, but you must give him justice. You are told the second reason why we should advise the head of state to dismiss Linturi is he revoked licenses for some factory. First of all, you have not even been shown the license in the first place, because for a license to be revoked, it has to exist first. You have not been shown this is the license that was in place that the Honorable Linturi revoked. You have not been shown an instrument of revocation. Licenses are granted in writing. They are revoked in writing. The Honorable Linturi, as a Cabinet Secretary, is not even a licensing officer. under any regime of the law. We have more than 1,000 chapters of the laws of Kenya. There is none in which the Honorable Linturi or any other cabinet secretary for that matter is a licensing officer. Licenses are issued by regulatory bodies. So the question, therefore, again, even if we accept Linturi this time is not the twin brother, he is the devil himself, as we've been invited to believe. Can we really, in good conscience, in this historic occasion that is not precedented in the history of our republic, advise His Excellency to dismiss this good gentleman because there are serious reasons to believe he has committed a gross misconduct. You are told, Honorable Chair, still on this ground 3, that the evidence is a press statement. And I recall asking you in my opening, Chair, I know we say many things about democracy as a developing project in Africa, but I would be interested to know which country in the world, in which country as a cabinet secretary or even a sweeper of our streets, forget a cabinet secretary, has been dismissed from office because somebody somewhere issued a press conference over a matter they did not even witness. We were told yesterday when we ran the Evidence Act, you must have seen it with your eyes, you must have touched it with your fingers, you must have heard it with your ears. The author of this supposed press conference is Common Ground. They are not a journalist. It is Common Ground. They have not sworn a witness statement. It is Common Ground. They didn't come to testify. But nonetheless, because they believed. Or are we going to say because this press statement was issued by none other than the President of the Law Society of Kenya, therefore if the President of the Law Society of Kenya has issued some press statement, and this press statement is against that devil called Linturi, therefore we shut our mouths and say, crucify him. Heads must roll. Blood must let. I'm resisting the temptation, Honorable Chair, to say that this motion is very unfortunate because it is unfortunately trivialized. It has trivialized some important constitutional accountability framework. You know, we would expect if this very grave accountability mechanism is invoked, it has to be invoked on the right occasion, on the right facts, on the right allegations. That it could be invoked because Linturi has refused to fall in love with someone, because Linturi has refused to marry someone, because Linturi has such a bad perception, because Linturi has such a bad reputation. It is to trivialize and, I dare say, Chair, to scandalize our Constitution. Chair, I seek your protection because when the other side was speaking, it was listened to in silence. And I said, I am not a young child. I know my limits. I am a married man, as I said, to a beautiful wife and 3 children. So I'm just doing my job. Let me be allowed to do my job without interruption.
Members, let us know that this is the closing remarks, and let us allow the Council to proceed without any interruption. Thank you.
Thank you, Chair. You were told the other reason, Honorable Chair, is because some lawyer issued a demand letter. And because this lawyer issued a demand letter accusing Linturi at the instruction of his client of some wrongdoing, therefore there are serious reasons And I kept asking in cross-examination and examination in chief, Honorable Chair, I have practiced law for 17 years now and counting.